Speakers list. All right. Good afternoon. The Housing and Consumer Protection Subcommittee of the General Laws Committee will come to order. Members will make their attendance known on the attendance roll. The clerk will close the roll. A quorum is present. First up on our docket is going to be House Bill 782 from our Majority Leader Delegate Herring. You said you wanted to be first.
Yes. I had to raise my hand. Thank you so much, Mr. Chair, and members of the committee. HB 782 comes from the Virginia Bar Association. It was crafted with employment attorneys as well as plaintiff attorneys. The bill better aligns the state-level discrimination investigations with the federal EEOC investigations, providing more efficient, predictable, uniform process for both complainants and respondents. The problem that we're trying to fix is that there's a misalignment in the timelines and procedures for discrimination investigations by the Office of Civil Rights and the Federal Equal Employment Opportunity Commission. This means that complaints and respondents have to track and navigate two different, sometimes conflicting state sets of rules. This makes the entire process unnecessarily burdensome, duplicative, complicated, and for an employee to pursue a claim for an employer to respond. The solution is this. The legislation will align timelines for the completion of an EEOC or OCR complaint, requiring that administrative claims be filed within 300 days of the incident, requiring OCR to promptly issue its right to sue notice after EEOC closes its investigation. It will also require lawsuits alleging discrimination be filed within 90 days of the receipt of the right to sue notice. And Mr. Chair, I do believe that there are amendments. I apologize.
Yeah, that's fine. Council's handed me two line amendments. These are actually super technical. We just changed the reference on line 4 and again on line 11 to code section 2.23905. That should reference code section 2.23901. So what the line amendments do is strike 3905 and insert 3901.
Move the amendment. Second.
It's been moved and properly second. We adopt the line amendments. As many as favor that motion will say aye.
Aye.
Those opposed, the motions are before us. Delegate Herring, one quick question for you. So it sounds like this is 100% pure procedural, right? This just has to do with the timing and the outlines, and it doesn't create any new rights or take away anybody's rights or create any new causes of actions or eliminate anybody's causes of actions. It just has to do with the timing of the causes of action. Is that correct?
Mr. Chair, you're absolutely correct.
All right. Any other questions from members of the subcommittee? Anybody in the room wishing to speak in favor of the bill? We all like this bill.
Thank you. Chair and members of the committee, my name is Craig Kerwood. I'm the past chair of the Virginia Bar Association's Labor and Employment section, and that is a section of about 300 employment and labor lawyers of both representing employers and employees, and this is a procedural issue only that this bill addresses, and this was the result of employer and employee advocates working together to try and fix this procedural issue.
Thank you.
Thank you.
All right, is there anybody in the room wishing to speak in opposition to the bill? All right, we have somebody online. I think Tammy Miller-Jennings from Virginia Now. I see that you're there. We appreciate your support. So it's noted for the record, Tammy Miller-Jennings of Virginia Now supports House Bill 782. It's been moved and properly seconded that the bill report. The clerk will open the roll. As amended. The clerk will close the roll. The bill reports by a vote of 8-0.
Thank you, Mr. Chair.
Delegate
Members.
Herring. All right, Delegate Oates. You have a bill, and I just want to confirm with you while you're here. You have House Bill 1092, and it sounds like it's been explained to you that we don't generally legislate the building code, but what you'd like to do is have this bill continue to 2025 so you can continue the conversation with building code officials. Is that right?
Yes, if it would be the pleasure of the committee and the chair.
All right. Is there a motion?
Continue. Second.
It's been moved and seconded that this bill be continued to the 2025 session pursuant to Rule 22. As many as favor of that motion will say aye.
Aye.
Those opposed?
Thank you.
Congratulations. Your bill is continued. Delegate Early. You have House Bill 877.
I do.
Delegate Early, you have the podium.
Thank you, Mr. Chairman, members of the committee. This is House Bill 877. Thank you all for having me today. I do think there should be a substitute.
Council, do you have a substitute? It's online. It's been moved and seconded that we adopt the committee substitutes. May further motion will say aye. Those opposed? All right, the substitute is properly before us.
Mr. Chairman, what House Bill 877 would do would be to establish the Virginia Social Media Regulation Act. So we are about a decade or a little more than a decade into this sort of real-time social experiment with the smartphone and social media. And we have begun to see the impact not only on all of us, but more importantly on our kids. And the research is in, and I would say it's indisputable. More and more studies are showing the incredibly harmful effects of social media on our youth. And as a parent of young kids and having a lot of peers who are parents of young kids, I see this massive impact firsthand, and I believe it's time to act. So this bill, again, would establish the Social Media Regulation Act. And what it would require would be that if minors are going to have a social media account, parents must give approval. It would also require that social media companies provide parents with access to these accounts. It would further prohibit certain kinds of data from being gathered and compiled from the minor's account. And lastly, it would require practices be implemented to not employ features that are known to cause addiction and be addictive. So it would be enforced via the Virginia Consumer Protection Act. And I don't want to take the committee's time, but I do just want to very, very briefly run through a couple things that I think are really important. If any member has not taken a look at the Surgeon General's advisory that came out last year on social media and youth mental health, I would highly recommend it. Just a couple major points. There's really three problems that we have that come from this. Number one, we have addiction. Number two, we have harmful content. And number three, we have practical danger. So according to this report and other sources, virtually all teens, 95% of ages 13 to 17-year-olds use social media, with more than 1 in 3 reporting that they use it almost constantly. While most U.S. social media platforms say that they require users to be at least 13 years old, at least 40% of kids ages 8 to 12 also use social media. Number two, the harmful content. So nearly 2 in 3 adolescents are exposed to hateful material via social media. And again, this is according to the Surgeon General report. And there's also a direct correlation between cyberbullying via social media and depression. And then turning to the practical danger, teen girls are the most vulnerable category, showing huge percentages of them not only saying that they're depressed, and that's correlated to their high use of social media, but also 6 in 10 adolescent girls report having been contacted by strangers via social media in a way that made them uncomfortable. And I would just say, I think parents, and I can attest to this personally, but also just according to this report, a majority of parents say that they are somewhat, very, or extremely worried that social media could lead to their child's anxiety or depression. And while they are doing the best they can to parent on their own, I think it's pretty clear that they need help and assistance. So we could go on all day about this, but I don't want to take the committee's time. Obviously, I'm not advocating that we abolish social media or anything like that, but I do think the Commonwealth has a legitimate interest in and should implement a regulatory framework, especially when we're talking about kids. This is about protecting kids from harm. So I appreciate the committee's time and attention, and happy to answer any questions or go from there.
Thank you, Delegate Early. Delegate Price.
Yes, Mr. Chair, I have a couple of questions.
Delegate Price.
Okay, so I'm trying to work through the substitute without having direct access to it, so I just want to make sure. So when you're setting this up, it's very prescriptive, so it's not really allowing much interpretation or regulation for that point. But when we're talking about parental access, what is the logistical way that the parent is receiving the access to the minor's account and information like the password to the account if they're not also account holders, or does this mandate that the parents would also have to be account holders?
As to the very technical aspects, I think that's going to be up to the companies to figure out how exactly that works. But essentially, the point is to make sure that they have access and oversight, again, just for minors specifically.
Mr. Chair.
Delegate Price.
Yeah, and that's kind of what I'm getting at. It's very prescriptive, but then yet doesn't prescribe how to do it. So I'm just trying to work through the practical applications of this, completely understanding what it is you're trying to do. With the hours of 10:30 to 6:30 a.m., what was the, I mean, I'm probably able to infer, but what was the rationale specific to those times?
Sure. So in this Surgeon General's advisor they put out, they talk about, I think, something like 1 in 3 minors report losing significant sleep because of their social media use and staying up past midnight because of it. So, and again, these kind of things can be tinkered with. They're not set in stone, meaning the parents can adjust it if they find it appropriate to do so. But that, to answer your, or excuse me, I'm sorry, Mr. Chairman, the answer to that question is the prompt for it comes through the findings of the Surgeon General Advisory.
And Mr. Chair, I guess my final question for now. So when we're looking at the civil penalties, can you just walk through which of the penalties are for the social media company, which of the penalties are for the parents? Like where does the responsibility lie within the penalties?
The social media companies. Mr. Chairman.
All of the penalties are for the social media company. So the parent, Mr. Chair. Sorry. Thank you. The parents have access and information for all of this, but is there anything within this that I guess the parents would have responsibility for, or the responsibility for any of the penalties and I guess responsible usage of social media for their children is on the parents?
Mr. Chairman, no, I think the answer is no. None of the sort of liability would lie on the parents. It's all about giving them access and control for the minors. But the liability, if there's, if the parents are denied access or anything like that, then the liability would be on the social media companies.
Okay, thank you.
All right, anybody else from the committee have any questions? All right, if not, can we hear from anybody in the audience who's here to speak in favor of the bill? Anybody here to speak in opposition to the bill?
Good afternoon, Mr. Chairman and members of the committee. Elizabeth Rafferty, Hunt and Andrews Kurth, here on behalf of the Northern Virginia Technology Council. This bill establishes a whole new act within the Consumer Protection Act and imposes significant new requirements on businesses in the industry. The impacted stakeholders and industry should have input on how this is created. Some of the language and new definitions are vague and would be very challenging to enforce. As an example, the definition of addiction includes if the use of the platform causes physical, mental, emotional, developmental, or material harms to the user. This is exceptionally broad and far-reaching. Additionally, this bill is preempted by the federal law, the Children's Online Privacy Protection Act, which is currently set at 13, and under federal rulemaking right now, it is considered bumping from 13 to 16, but it still has the 13 age provision right now. We ask that you allow JCOTS to review this bill along with the numerous other bills that touch social media and this area of the Consumer Protection Act and Consumer Data Protection Act over the course of the next year and come back with recommendations from JCOTS. Thank you.
All right, is there anybody else in the audience wishing to speak in opposition to the bill? All right, we're back to the committee. Delegate Price.
Yes. Mr. Chair, thank you. And I do want to say to the patron, I understand. Like, I have read this, I've seen this in our summer programs, how this is impacting our kids. But when we do have such a significant crisis, I think how we respond has to be in a responsible way with the stakeholders at the table. So I have a motion at the appropriate time, but just letting you know, it would be for us to allow for that conversation so that we can get to a product like this, but with more input.
Anyone else wish to be heard on this bill? All right, Delegate Price, this is the appropriate time.
Yes, so I would move that we lay this gently on the table and ask our Uber chairman to send a letter that could convene a work group in order for us to get to the proper bill next year. Second.
All right, it's been moved and properly second that we lay the bill on the table with a letter to the with a letter from the chairman to JCOTS asking them to take a look at these studies, possibly assembly work group or stakeholder group, but send it over to JCOTS. It's been moved and properly second. That motion is not debatable. The clerk will open the roll. The clerk will close the roll. That bill is laid gently on the table by a vote of 8-0, but we'll send a letter. Delegate Bulova was nodding his head affirmatively that he agrees to send such a letter to Jay Cotts, and we'll take a look at this important issue. Thank you for bringing
Thank you,
this
Mr.
issue.
Chairman.
All right. Delegate Williams.
Thank you, Mr. Chair.
Delegate Williams, you have HB 852. Please tell us what your bill is trying to do.
Bill 852 is trying to solve a problem that we have with volunteer fire departments in our local communities. They are regularly called out to car wrecks and other types of emergencies that are not necessarily house fires or fire related. And that takes a lot of time and expense and cost. And they're not currently able to bill for that towards insurance companies. So this bill is pretty simple. It just allows for the counties, cities, and towns that the fire department is located in. They might also add an ordinance for billing on behalf of volunteer fire departments for provisions of EMS. And that's defined in this other code section, and I pulled it up. Emergency medical services, or EMS, means healthcare, public health, and public safety services used in a medical response to the real or perceived need for immediate medical assessment care, transportation, preventative care, or transportation in order to prevent loss or life or aggravation of psychological illness or injury. So we've got fire departments who are responding to emergencies but don't necessarily recoup any of the costs and everything that goes with it. I am okay, and this bill doesn't address it right now, but if there is concern about hard billing, I would be comfortable with an amendment that said something to the effect of soft billing, where it's you send the bill, if it usually just to the insurance company. If it's not payable, it just goes, it's probably written off, but it doesn't go to the consumer. That's what a lot of local EMS will do on the EMS side. This just adds the same opportunity for the fire department side.
Thank you, Delegate Williams. You sort of anticipated my question here, and if you can maybe help me, and maybe there's somebody else who could help understand how that process works. Like, I get, right, that there are folks that have insurance that covers these ambulance rides. They've already paid the premiums into this insurance. It's paid for, essentially, but you're not able to pull it down if there's no bill to submit to insurance. And so this would allow the volunteers to generate a bill. The question is, how do we generate that bill and not also capture people who maybe can't afford it, and then discourage people from calling the ambulance and getting the services they need because they're afraid of what bill they might be hit with. So you've introduced the sort of concept of soft billing. Can you tell me a little bit more about how that would work?
Yeah, I'm not super sure how to define it in a code section. Would be open to help with that, but effectively the goal would be if you have insurance. Basically, what happens is a bill is sent. If it goes to insurance, they might pay it. If it doesn't go to insurance and goes to the consumer, they don't have to pay it. That is basically what soft billing is, and there's no collection effort to pay it. There's no getting sent to credit report. There's no getting sued in court. There's no collection on a soft bill, which a lot of EMS ambulance services will do already.
I think probably the problem is we can't codify it that way, or the insurance companies just won't pay it because they'll say it's not really a bill. So at any rate, let's see if we can hear some folks in the audience. It looks like I have some folks that are here to speak in favor of the bill.
I don't.
Do we have anybody here speaking in favor of this bill? Oh, no, okay. Anybody here in opposition? So I guess the question is, what's the pleasure of the committee? I get the problem you guys are trying to solve. I get the value of doing it. I do, and I know that, I think Fairfax County instituted this, I think when I was working for the Board of Supervisors about 25 years ago. There was some concern about it, and it's worked out. It kind of just doesn't go after folks they can't pay, but go ahead.
I'm not quite sure, but I think there might be something else in the code that talks about like a true fire tax that a county puts on, but this is obviously what you just said, which is like the soft bill approach, and I'm trying to just help emergency fire or volunteer fire departments. So if this isn't the approach, I'd be fine with this going somewhere else to just try to figure out how this might be something that could be worked out, but I don't have all the answers. Y'all know that.
So again, I like this. I think this problem needs to be solved. Here we are, right? The problem is, I hate to say this out loud, but we are running out of time. Boom, boom. Somebody's bingo card. Here's how I maybe suggest we deal with this issue, if it's okay with you, is if you consider a friendly amendment that we just throw a reenactment clause on this.
Sure, yeah.
And then we send it out and we can, you can keep working on coming up with some of that language and see if we can come up with something that satisfies those concerns and as it works its way through. But we put a little, as the big chair calls us, a little speed bump on it so that it doesn't get away from us without getting that part of the problem solved.
That's fine.
All right, there's been a motion to add a reenactment clause. As many in favor of that motion, is there a second?
Second.
All right, moved and properly second. As many in favor of that motion will say aye. Aye. Those opposed? All right. So with that, is there a motion on the bill? Oh, I'm sorry, Delegate Arnold, did you want to? No. Okay.
Report is amended.
All right, it's been moved and properly second. We report is amended. The clerk will open the roll. The clerk will close the roll. That bill reports 8-0. Of course, it won't actually become the law unless we solve the soft billing problem. All right. Thank you, Delegate Williams.
Thank you. I've got,
You have another bill,
yeah, it's pretty simple.
an easy one. All right, House Bill 1351, Delegate Williams.
Yes, this bill is just meant to address something that we found that was happening with the VASAP Commission interlock systems. Effectively, somebody would get pulled over, get arrested for a DUI, would not be found guilty yet, but we'd have ignition interlock system individuals sending out letters suggesting that they need to go ahead and get an interlock system into their car without that being very clear that they did not have to do that. There was some implication that they should, and they should get that taken care of. So this was a bill that basically said that if you're going to solicit, then you need to put a statement on it that says this is not from the government, effectively.
Questions? Any questions from members of the subcommittee? All right. Anybody here to speak in favor of the bill?
Good afternoon, Mr. Chair, members of the committee. Christopher Morris with the Commission on VASAP staff. What this does fix, as Delegate Williams was stating, is we ended up canceling an interlock vendor's contract last year, and one of the reasons was deceptive marketing practices. So what was happening is it was going to clients before conviction, and it was on the fence of looking like it was coming from the state of Virginia. In addition to that, it was pre-conviction, and the clients felt like they had to put an interlock in. What we want to make sure this doesn't do is go so far as post-conviction, that once clients are convicted, they do come to the local ASAP program and get interlock brochures, and we also have the interlock information online for them to get. We want to make sure this doesn't go that far and make that fraudulent, because at the state office, we of course don't want to be participating in that. So it's a great bill. We love what he's doing on this. We just want to make sure it doesn't penalize us or an interlock vendor that's trying to get the information to the client post-conviction.
So, Delegate Williams, I'm looking at this language, right? So it's fairly short. It says, advertising any ignition interlock system without a conspicuous statement that the advertisement is unrelated to any criminal proceeding or government agency. So what if it is? I think it's what they're hearing. What if it is related to a proceeding or government agency? It doesn't say unless, we don't have like language that says unless it actually is or something like that.
Yeah.
That's what these guys are saying.
I would love to fix that issue. And if you want to.
Delegate Price.
Yes, Mr. Chair, I wanted to ask the gentleman, so once it is post-conviction and it actually is, hey, you need to get this, who sends that out? Is that an advertisement or is that a letter from a state agency?
Mr. Chair, Delegate Price, it actually, the 3 state-approved vendors put their brochures in the local ASAP programs, and then we have the information online. So if they call us, we can simply say, go to our website under our frequently asked questions, and then they pick up the brochures at the office, and then they can call their vendor and schedule their appointment.
And then follow-up question?
Delegate Price.
So thank you. So if we were to add, unless it's, post-conviction, would that alleviate your concern in whatever legal language it should be appropriate? But if there was a time frame that it was after, it was okay to send after conviction, would that alleviate your concern?
Mr. Chair, Delegate Price, definitely.
So, Delegate Williams, you want to go by temporarily and see if you guys can't hammer out some words for us?
That'd be fine.
Delegate Arnold.
A question for the witness. Thank you, sir.
Delegate Arnold.
I would ask the VASAP, am I correct that there's only 3 state-approved ignition interlocks. Did I hear that correctly?
Mr. Chair, Delegate Arnold, there are 3 approved interlock vendors in the state of Virginia.
I thank the gentleman.
You're welcome.
All right.
I move that bill go by temporarily.
Yeah, so speaking to that motion real quickly, I think we like this bill. I know we have this problem in my world with people sending people solicitations to get a copy of their deed, and pay $150 for it when I can get it for them for $30 or for free by just downloading it and printing it. So I get the practice. I think you're onto something. We just want to make sure we don't have any unintended consequences. So that bill, without objection, by temporarily.
Thank you.
Oh, I didn't need to gavel it, did I?
Emphasize it.
Temporarily. I got it with the, getting a little excited. All right, Delegate Krizak. Delegate Krizak, you've got a time-consuming bill. This is not a quick and easy one.
No. House Bill 1397, Mr. Chairman, members of the subcommittee.
Is there a substitute on this bill?
I'm sorry?
Is there a substitute?
Yes, there's a substitute.
Second.
Moved and properly seconded, we adopt the substitute. The reason I'm going through that so fast is because we want it to come up online, and it takes our iPads just a minute to make sure we can see it.
No,
There's been a couple
worries.
versions of this. So Delegate Krizak, speaking to the substitute, which is now available online, I hope. Yes, it is. Go ahead.
Okay, thank you, Mr. Chairman. So House Bill 1397 increases from 60 to 90 days the notice manufactured home park owner must give residents of any potential sale prior to final acceptance of an offer to purchase the park. It does not apply to sale to a family member or via blood or marriage or to any person or entity who already owns a portion of the park. Notice also must be provided to the Department of Housing and Community Development and the locality in which the park is located, and it must state the price and terms and the conditions of the offer received by the park owner from the third party. That's the notice. If an association representing at least 25% of the park residents or a nonprofit or locality at the request of the residents makes an offer to purchase, the landlord must negotiate in good faith, and if the park owner does not accept the tenant's offer, they must provide reason for non-acceptance in writing. If a tenant's offer is accepted, the residents or designee will have 30 days to secure financing. Virginia's manufactured home parks are increasingly being purchased and closed by corporations who want to replace the parks with more lucrative, less affordable housing. I have 5 manufactured home parks in my district. They provide fantastic affordable housing for low-income individuals and their families. And this bill will give them a chance to purchase their parks and giving them greater housing and economic stability. It also provides the right of first refusal for the locality to purchase the manufactured home park, provided that they maintain it as a park for at least 30 years following the sale. This enables localities concerned about losing affordable housing the right to purchase at-risk mobile home parks to maintain that critical affordable housing in their community. Localities would not be required to maintain ownership for the full 30 years, but any sale made during that time would have to continue the initial provisions of the sale. New owners would be required to keep the land and manufactured home park until the end of the 30-year period. It also increases the amount a park owner must pay to each resident if the sale of park forces them to move. Right now, it's $3,500 in Northern Virginia. It's $2,500 in the rest of the Commonwealth. It would move up to $5,000, which really still is not enough if you have to move your mobile home. It usually costs around $10,000 to $12,000, maybe even more than that. And you're responsible, if the park gets sold, you're responsible for moving your mobile home right now. And you would, some of these homes are not even, can't be moved. They really shouldn't be called mobile. And additionally, the offer to purchase cannot contain a penalty clause that requires the park owner to pay the purchaser a penalty if the sale isn't finalized. And finally, under the bill, and we're trying to deal with a situation where if the locality wants to match the offer, and then and that's happened where the seller or the purchaser then told the park owner, if you go with that locality's offer, our $2 million penalty clause is going to kick in. Finally, under the bill, any resident with a valid lot lease in which the park is located can file an action in the circuit court where the manufactured home park is located for damages, injunctive relief, and attorney's fees. And I have a number of people here to testify, and some of them to testify online.
Yeah, before we get there, Delegate Krizak.
Yep.
So, and maybe this is a question for council. I know there have been a number of different versions of this substitute floating around. The one that's online On line 58, still talks about a nonprofit organization to which is, talks about a notice period from an entity of formal, informal, including one formed after the issuance of the notice required by the subsection that provides documentation that represents at least 25% of the owners or by a nonprofit which has assigned. Is that language great? I know the intent here is to get a right of first refusal just to the locality in the latest version. But I'm looking at this language. I'm wondering.
Is this what you're looking at? I'm just asking.
Yeah, it's line 58.
That's what you're looking at?
That's what I'm looking at. And it seems like we maybe wanted to get that out of this version, or if there's another version that.
It could be. We've been working hard. I mean, we've changed. We started, working with with all the different stakeholders, and we've changed the notice period from 120 down to 90 days. We've lowered the required relocation expenses from $12,000 to $5,000. We've removed the right of manufactured homeowners, tenants to challenge whether the contract price reflects the fair market value of the park. We've removed the right of first refusal provided to the residents. We've removed the statutory damages of 12 months rent for violation of the act. So there's been a lot of, and then in the last couple days, we've been we've been working with a lot of you on the committee, and I appreciate all of your input because you guys are very expert at this. And so we've been trying to craft a bill that will work for this committee and hopefully work for the Commonwealth. And if that is an issue and it does look like it's problematic, then let's take that out and I'll send out a friendly amendment. I also, maybe I can bring, so I think that was an intention, was to make sure that this was just for the locality, not for the nonprofits. A nonprofit could conceivably work with the locality.
Right. So I guess, and so D talks about if the locality wants to make propose a purchase agreement, they can do it, and it describes how it does that. C used to have a notice, just be a notice provision, and then you kind of turned it into a right to purchase. I don't know how we undo that. Yeah, so maybe Ms. Mara, if you can help us.
Thank you, Mr. Chairman. Christy Mara with the Virginia Poverty Law Center. Mr. Chairman, I think those are actually two separate provisions. So the provision you're talking about right now, which starts on line 58 of the substitute, actually gives the residents not a right of first refusal, but just clarifies that they have a right to make an offer. And then there's an additional provision down in subsection E that says if they make an offer and the park owner says, the park owner has to negotiate in good faith with them. And if the park owner after that says, no, I don't want to accept your offer, he has to tell them why in writing. Those two provisions, I think, go together, whereas I think that, the provision regarding the 90-day notice is separate and distinct from that, and that is the provision that's encompassed in subsection B. And I will say, Mr. Chairman, members of the subcommittee, that notice is important for more than just the purpose of advising the tenants that they might want to think about forming a resident association and making an offer. It's also important because then they know, hey, my park may be closed. Let me see what I need to do. And if this subcommittee sees fit to move the bill forward with the locality right of first refusal, that notice to each individual tenant becomes even more important because then they are able to come together and say, hey, we need to go talk to somebody at Chesterfield County, somebody at Fairfax County, Fairfax City, to see if we can get them to help us.
All right, Ms. Brown, I get it. I see what's happening. So see, it's just hard to read through the strike-throughs and the underlines to make it a coherent sentence. But it looks like what it's saying is in section C, you have a 90-day notice period, and during that period, the nonprofit organization or the entity can make an offer. Correct. Just say, hey, you got 90 days. This is your time to think about making an offer. But D goes much further than that. It says if the locality wants to, they have a right to match the terms and conditions in the existing proposed purchase agreement, as long as it contains a commitment that they'll maintain it as manufactured housing. And that's sort of like what we did in an earlier bill that Delegate Bennett Parker had come through this subcommittee on preserving affordable housing of certain types. That, the locality could do it. All right. I'm just trying to make sure, again, thank you for that clarification. I don't mean to slow you down, Delegate Krizak. I'm just trying to make sure that we get it right. All right, any other questions for members of the subcommittee? All right, seeing none, you said you have a number of people here to speak in favor of the bill. Why don't we hear from folks here in the room that are here to speak in favor of House Bill 1372, 1397. Yeah.
Mr. Chair,
Hang on for just 1 second. I want to see how many folks we have Again, we do have a long docket, and we're the first in a series of back-to-back-to-back dockets. And so we also have, it looks like about 7 people online. So if we could do, set a timer for 1 minute. Well, what would you guys rather have me do? You want me to have a big block of time for you guys to split up amongst yourselves, or 1 minute apiece?
Mr. Chairman, I would like 5 minutes for in-person and 5 minutes online.
All right, we'll do that. Delegate Creases. We'll do 5 minutes for the in-person folks and 5 minutes for the online folks, and then we'll do something similar for the opposition. All right, go ahead.
Mr. Chair, members of the subcommittee, my name is Daniel Rezai, Virginia Poverty Law Center. We do support this piece of legislation. In my legal practice in Southwest and Central Virginia, I have seen firsthand mobile home owners be taken aback by finding out their park is being sold because they never received their notice. Or if they did, it was just taped to their door in the middle of a wind and a rainstorm by the property manager of the park. I don't want to rehash everything that has been said, but I think what is very clear here to keep in mind is these 90 days give these people that own their homes the opportunity to contact their locality to see if the locality has the funds necessary to purchase their park, so that for the next 30 years they can guarantee their home doesn't have to potentially be moved or have to be left behind due to redevelopment. In areas where redevelopment of land is the top priority, you have people in manufactured housing communities who are losing the place that their home has been for potentially 20 or 30 years because of the need of redevelopments. And this gives those local governments the opportunity to keep those housing opportunities available to people in a very good access to low-cost housing available in places where population density is increasing. This legislation also does finally have some enforcement provisions that we believe are essential in making sure that buyers and sellers of these manufactured home communities are doing what is necessary to provide notice to the people living in their communities. And if they don't, there is now an enforcement mechanism which gives those tenants the ability to enforce the law as against those buyers and sellers, where now if things are not followed, they can't do much of anything but complain after the fact. And we appreciate you all voting in favor of this legislation.
Thank you.
Hello, I'm Gustavo Espinosa with the Legal Aid Justice Center, and I urge you to vote in favor of HB 1397. I organize with lots of residents of manufactured home communities in rural and urban areas, and everywhere I go, I see a phenomenon of mom and pop landlords selling out their parks to predatory corporations and private equity groups that see these communities as a cash cow investment with a captive and vulnerable clientele. They jack up the rents, decrease services, take residents' autonomy away. They displace people, they bulldoze and redevelop, they resell it, they break up strong communities. Many times, residents don't know what the private buyer's intentions are. Residents want some assurance that someone, a locality with good, transparent intentions can have a fair shot at buying the community and keeping them together. Lastly, we hear a lot of concern from the landlord lobbyists and also from members of the committee about the landlord's freedom of contract, but we're seeing firsthand that these same landlords are insisting tenants give up their freedom of contract. I've seen leases and rules where the landlord has the right of first refusal on residents' own homes. Please help level the playing field so communities have a chance to stay in their homes and stay together. Thank you.
Hi, I'm Alice Tuziant with the League of Women Voters of Virginia, and we support this legislation because one other fact that hasn't been brought up so far is manufactured homes are the largest source of unsubsidized affordable housing in the U.S., and we need to preserve this housing and protect the tenants who live there. Thank you.
Good afternoon, Chair, members of the subcommittee. Isabel McLean with the Virginia Housing Alliance, and we also support the bill for the reasons previously stated. Thank you.
Good afternoon, Kashish with New Virginia Majority, and for the reasons stated, we also support this bill. Thank you.
All right. Is there anybody else wishing to speak in
Chris,
favor?
do you want to say any final words? We've been working hard on this, and I appreciate all the stakeholders, including the folks who are going to come up next, but we still have 1 minute and 16 seconds.
Thank you, Delegate Krizik. Mr. Chairman, members of the subcommittee, as has been said, what this is really designed to do is to make sure that the residents have a realistic opportunity to preserve their housing and preserve their community. One thing we see when we go into these communities is that it's not just a collection of homes. It truly is all of these communities that we go into truly are cohesive communities where people look out for each other, where families take care of one another's children, where people socialize together. What we have also seen, and what I think this bill can accomplish, even if the right of first refusal is solely provided to the locality, is that we have seen in two very specific instances where localities worked with the residents and with nonprofits to help the nonprofits purchase those communities when they were at risk of being sold and redeveloped. In those two communities, one in up in Manassas City, which is East End Mobile Home Park, and the other in Chesterfield, which is Bermuda Estates, have really become much more they've become healthier, they have become more cohesive. Those nonprofits have made great improvements. Everyone has not only maintained their affordable housing, but it's been improved.
Thank you, Ms. Mara. Thank you, Delegate Kriesek. All right, online, we've got some more supporters. And so we'll start with Ms. Carolyn Carter. And again, you guys have a 5 minutes total, so keep in mind that be courteous to the folks behind you in the queue. Is there Ms. Carolyn Carter online? All right, seeing none, is there a Larissa Zare?
Good morning.
Go ahead, Larissa. Sorry.
Thank you very much, Mr. Chair and members of the committee. My name is Larissa Zare. I'm with Legal Aid Justice Center, and we support HB 1397. In the last 3 years, I've worked with park residents of 3 Fairfax County mobile home parks to organize a counteroffer of purchase. In a minute, you're going to hear more about that. All of these efforts failed because this section of Virginia law does not do what it is intended to. This bill would create a concrete path for residents to have a fair chance to participate in a market sale. I just want to highlight 3 really important parts of the bill. The current law requires that an owner consider an offer from residents. The word consider is not defined, and we found that word is meaningless in practice. The new bill would require an owner to negotiate in good faith with residents and inform them of any reasons for denial. This bill also protects an owner's option of selling to residents by preventing a buyer from putting a penalty clause in their offer. In essence, what we see is that often the residents fail to be able to make an offer before they even begin because there's a penalty clause in the buyer's contract. In essence, removing this would protect freedom of contract for the owner to sell to residents rather than a buyer restricting their choice. And it allows residents a 60-day window to finalize necessary financing if they need it. By the time they have organized a purchase offers, they may have lined up financing long ago. The Commonwealth should allow manufactured home park residents a fair shot to transform their future. Thank you very much.
All right, next up we have Marianela Funes.
Yes, thank you for letting me be here. My name is Marianela Funes, and I am community organizer with Tenants and Workers United. I have been working the last 3 years with the mobile home community along Route 1 corridor. And I have been how communities of colors and workers family have been displaced. And even though they have been making huge efforts to buy the land where the houses stand, they haven't been taken into consideration. For example, Harmony Place is in a community. They got a 60 days notice of sale. And in that time, they create a tenants association. They find a nonprofit who was willing to work with them. They got the financial support from the local government, from Fairfax. However, the community came out with a counteroffer 2 days before the closing date. And even though the community offered $0.5 million more than the first buyer, it wasn't enough to overcome the cost of the penalty clause. So even though the community worked so hard and they got the money, they didn't even was taken in consideration. And the other parts were Race and Ingleside. The seller refused to even consider an offer from the tenants because he had a contract with a buyer. And the situation was similar. The tenants created the Tenants Association, got a nonprofit that was willing to work with them. The county was willing to help the community, but also they have only 60 days and they couldn't even come with a counter offer. And in this case, the seller even refused to take in consideration the offer of the community. So HB 1397 will make a huge impact for mobile home residents because this bill will give a chance to members to keep their homes affordable and protect them from displacement. Thank you.
Sorry, Karen Crosdale.
Hi, thank you for having me. My name is Karen Crosdale. I am part of the Pendon community, part of the Route 1 corridor. My community consists of 90 homes and is also in the midst of a very fast-paced development with high-rise luxury apartments. Many of our communities have already been sold, and we've already experienced many of the mobile home communities being sold and not having the opportunity to have the time to be owners of their land. So if you could just review and consider the bill 1397, we would greatly appreciate that.
Okay, we have a few seconds left for Mary Padden, or Padden. Mary.
Thank you and good afternoon. Mary Payton, I'm the chair of the South County Task Force. It's a group of advocates for social justice on the Route 1 corridor in Fairfax County. We work with all the people you've just heard from. We've been working, we support Bill 1397. Along this corridor.
Thank you, Mary. I'm sorry. I tried to give you a little extra time for my time that I was off mic. Thank you so much for your opportunity to testifying, telling us who you're with. But we have run out of time for this particular bill. But thank you very much for registering your support. All right. Those in the audience who are in opposition to the bill, please come forward. And we can set a timer at 5 minutes. I think you guys, I mean, if it's 5.5 or 6, I'm not going to cut you right off because we had both online and in the person, but you guys get the idea.
Good afternoon, Mr. Chair. Randy Grumbine representing the Virginia Manufactured and Modular Housing Association. First, we would like to say thank you to the delegate for working with us in the early edit process and listening to the many objections that we did have to the bill. I have just seen the substitute for the last 3 minutes. I do have a question if what substitute is before the body. There's one online, but there's another one in paper, so I'm not sure where we're at on that. If that could
So the one that's properly before us is got a date on top of 2/8/24, and it's timed at 7:59 and 35 seconds a.m.
I'm looking at one at 8:02 a.m., Mr. Chair.
It's 8:02.
Yeah, 8:02. Which one's on?
Okay, so the one online is the one that I talked about, which is 7:59:35.
May I have a copy of what's online?
All right.
So anyhow, I'm a little uncertain on the difference, but I will say that there's been significant improvements to the bill, but we're still in a position where we're going to be opposed to this legislation. I would say.
I'm sorry, Randy, I'm sorry. If you could just, the committee will be at ease for just 1 minute. Oh. Resolved the issue with the timing. The ones that printed a couple minutes later than the ones that were created as PDFs. So the timestamps, right, we're all working off of LD 241-07465D. And so, Randy, if you have some questions, Mr. Grumbine, I'm happy to answer them.
Thank you, Mr. Chair. I will just say that we are in support of preserving communities. We recognize that the uniqueness of the communities, but we also recognize that there may be occasions where the use of that community is better served as something other than a manufactured home community, and we would let the free market determine that. We also recognize that there needs to be provisions to relocate tenants in the event that a community is receiving a closure. This bill takes it to $5,000. We feel that there's a lot more that can be done in this area because the delegate is right. $5,000 doesn't come anywhere close to the cost to relocate a home today. So we would like to continue to work on that section of the bill. to get to a place where we're all comfortable and it serves those folks that need to be relocated. The process that's on DHCD's site today, it's been in effect, codified by this body several years ago. In the last 3 years, there's been 164 notifications placed on that site, and I would venture to say the majority of those have resulted in a transaction with a new community owner. And we are only aware of one community that is closed in that same window, and the tenants had to be relocated. So, yes, it's made some improvements, but the end result is we're still uncomfortable with this language, just seeing it here in the last few minutes. But we'll continue to work with the stakeholder and the other folks that have an interest in this arena. Thank you.
Thank you. Mr. Craddock, you want to add something to that?
Pardon?
Go ahead.
Yes, sir. Mr. Chairman, members of the committee, Tyler Craddock, Legislative Strategies Group on behalf of Manufactured Housing Communities of Virginia. We share the same concerns of Mr. Grumbine. A couple of things particularly I would point out. He's right. We do know that we need to work on the relocation provisions. I would say to you that in terms of solutions, though, and yeah, we're all about, my members are in the business of running manufactured home communities, right? We're not in the business of buying parks just to sell them and convert them. We sell housing. And to that extent, we would encourage you to look instead at ideas. For example, some states have created relocation and replacement funds, right? Replace those old homes that Delegate Kriesik mentioned, so that when they're relocated and replaced with more energy efficient homes. Also, in states, there are provisions for creating financial capacity for residents who want to buy their community. Those are the larger kind of solutions that we think we should look at, instead of ones that simply say, hey, property owner, at the end of the day, if whatever the favored entity is right now in this version of it, it's a local government. This contract buyer over here who's going to buy it and operate it as a park, we don't think they should. We think this person should be shown favor over here, and that's just a bridge too far for us on our members' right to contract, and so for that reason, we would encourage you to oppose the bill. Thank you.
Thank you. All right, Delegate Coiner.
Thank you, Mr. Chair. Speaking to the bill?
Delegate Coiner, you have the floor.
So I do real estate law, and I spoke on Delegate Kriesik, so this is no secret. I love the intent of this bill. I've worked on both sides of several sales and several closures of manufactured housing communities. My heart is for the residents who live in every community, and you only take on cases when I know the outcomes are going to be best for the folks who live there, whether that means relocating or whether that means figuring out how to get a park into compliance and staying. So my heart is exactly where the intent of this bill is. But being a lawyer, my lawyer hat on, it's not crafted for me in a way that makes sense from the perspective of also our obligation to protect property rights. And it's also a really heavy lawyer bill. And I don't like it. I think it results in folks seeing counting heads of how many people they can go get on as clients if something goes awry and get a whole bunch of money, and the winners end up being all these attorney's fees instead of people. So I just wanted to point out a few things that, if this bill moves forward, that should perhaps be looked at. I agree with the folks who spoke about the dollar amount being low, but also making sure if we're going to give folks relocation expenses, I think we need to decide, is it more important to have the unit moved and what that really costs, or is it more important that we don't care so much about the unit being moved and that folks have money if they want to go buy something new? And I think that's an important distinction, because how we word this, if you get the money and you don't move it, could be an action against you for not actually moving the unit. So I think that in lines 15 through 16 is an important thing to clear up. I think as you move to lines 27 through 29 about when it doesn't apply to situations, You may want to account for folks who are involved in tax-deferred exchanges and other things where they're swapping out interest with different things that they own a percent in, and I'm not sure it accounts for that. I think that's a fair way to treat folks. I think there's just some missteps in language in 35 through 38 in conflict with the language that's used in 43 and on. I think when you're looking at in line 38, at least 90 days prior to, I think we mean settlement, not accepting an offer. And that's an important distinction, because if we provide notice and don't allow you to finalize an offer, those folks can walk.
I think you're looking at the wrong, that is, it does say now, at least 90 days prior to finalizing the contract for sale.
So that's a different terms. That's the verbiage I'm talking about. So later on down below, we talk about the notice being 90 days before the closing date, which is really probably the correct term to be used in line 38.
We can make that change easy.
So clearing that up. I also think when you look at how long we're giving a locality if they purchase it to preserve it as a manufactured home park, and that 30-year limitation might be something worth considering as well. When you come over to lines 84 and 81 through 85, really, when we negotiate in sales contracts between buyers and sellers, and if you end up not closing, there are costs that everybody's incurred, and we're really kind of letting these folks be treated like they're not a real purchaser, and the state stepping in and kind of saying, we're going to tell you that there are certain terms that, if you were any other buyer, you don't have to play by in these rules, which I think if we're going to let you have all this time to try to organize and be a real buyer as a group, then we should treat you like a real buyer and let those terms be negotiated, involved with costs and other things. I have real concern as someone who does settlements over all of this stuff in 90 through 99, all the affidavits being recorded. I do not like things being put in the land records that mess up title for forever and always in regards to if this doesn't happen and it's still of record, you go 2 transactions down the line and someone says, well, do you have proof that you sent all these notices out, and where's the file and the record on it? I think providing notice perhaps to the locality or just to housing and community development should be sufficient rather than clogging up the land records. I think looking down at lines 106 to 109, again, for me, is a whole bunch of attorneys making a lot of money. So sorry to my folks in my profession. Also down the same thing with how we're looking at attorney's fees. When we look at private contracts between folks in real estate, we kind of decide up front, if this doesn't go the way we all think it's going to go, who's responsible for what. And again, I am all for allowing owners to come together and to give them the time that they need to organize and to get the funding and partners in place to buy. I just think once they get that opportunity to do that, we need to let them be treated like a regular buyer. And I think, Mr. Chair, the second thing that I would say, I've been doing this now for 20 plus years. I've never seen in my region a park that wasn't falling apart sold, because you make a whole lot of money, sadly, off of these. It's really hard to do anything for the people who live there to buy it because it's so expensive. So I would love to work on legislation where localities can't discriminate against this kind of housing with you. Really looking at how we encourage this. I think there's a lot of potential in new manufactured housing communities being the most affordable housing we can really provide that folks get ownership in and equity. So I am all for the intent. I just want it in a way, I know other people maybe have concerns, but knowing that this may move forward, so it would be helpful to kind of see some of those things outlined.
Yeah,
Thank you, Mr. Chair.
I think a lot of what you've just said, Mr. Chairman, if I can, we can address certainly as we're moving forward. There's not too much. There's some of this is because we moved the time down from 120 days so it compressed it. So we had to put in these other guardrails, and I think that's not. I agree with you. That can be done. Certainly, the amount could be higher, and the language could be. And if there's a starker tax exempt exchange, that kind of thing, we can work on that. I think. work in progress, but I would like it to continue on.
We got a couple other folks that want to.
Oh, I'm sorry, there's others.
Okay. No, on the, from the subcommittee. So Delegate, I didn't want you to use your last word before it was actually the last word.
Don't want to use my last word.
Again, I don't think Delegate Corner was asking you questions, although she sounded like maybe she was more speaking to the bill. So Delegate Thomas.
Thank you, Mr. Chairman. I, as the other commercial real estate attorney on the other side of the dais, I have actually very similar things ticked off on here that Delegate Coiner just highlighted. I do have a couple additional ones, and the reason that we're making you go through this process is I'm going to vote yes today because I believe in the legislative intent of this, and I want to give you and all your stakeholders more time to work on this stuff with the understanding that we got to get some of this stuff worked out before we see it again at whatever next stage it's at. So in addition to what Delegate Coiner said, I would also say for lines, and not to turn this into a law class for everybody, I apologize. Lines 35 through 38, I think your intent is to hit pause on the sale process. And so I think we need to change that language to reflect that, because right now it looks more just the back end of the sales process, and we may not actually be pausing anything. There are other ROFR programs. I know this isn't technically a ROFR, but there are other ROFR programs in the United States that have very clear, I'm thinking of Prince George's County, Maryland, for example, that have a very clearly defined pause in the PSA process. And so I think that would probably be helpful language to apply there.
For the non-lawyers in the room, that's a right of first refusal.
Sorry.
It's okay.
And then my last comments, because Delegate Coiner stole all my thunder, is for lines 88 and 91, H and I. I'm not sure if those maybe conflict. Like if I'm just putting in my mind as the seller's attorney or the buyer's attorney, I'm not sure if those two might conflict. So maybe just take a second look at that. Not here to workshop that now, but I would just add those two items as well. And that's all I had, Mr. Chairman.
All right, somebody's hopefully taking notes. Ms. Marr, I see her, she's writing furiously in the front row. Delegate Price. Okay, so I think, to be fair, Delegate Krizak, what we've been doing with these things that we want to keep the process moving, but we also don't want to, once it leaves the subcommittee and the committee in the House, we don't get a second look to see if these changes have actually been made unless we do something like put a reenactment clause on it so that we know it'll have to come back from the Senate. We'll be able to see what kind of work was done over there, if it meets our concerns and they're addressed or not. So if we add a reenactment clause to the bill, and because again, we can't take it by for another day. There's no other day to take it by to here. So would you be amenable? Would you consider that a friendly amendment to throw a reenactment clause on it?
Yeah, that's fine. Yeah.
Okay. Is there a motion on to make such an amendment?
So moved.
Second.
All right, it's been moved and properly second. We got a reenactment clause. As many as favor that motion will say aye.
Aye.
Those opposed? Okay, Delegate Price. Did you have a? Okay. All right. Is there a motion on the bill?
Move to report.
All right, it's been moved and seconded that we report as amended with substitute and amendments. The clerk will open the roll. The clerk will close the roll. Delegate Krizak, tentatively moving forward. We're going to keep this going. All right. Thank you for your hard work on this bill. Thank you all the witnesses who participated and testified. A very critical issue, and we're taking it as seriously as we possibly can. All right. Delegate King. You are not on our agenda. You are presenting on behalf of someone else.
I am also on your agenda, so I would like to present on behalf of Delegate McQuinn first.
All right, you want to do House Bill 285?
Yes.
Okay. King.
Thank you, Mr. Chair. House Bill 285 relates to the Unified Statewide Building Codes related to bus shelters. It exempts plans and specifications for bus shelters within the 256 square foot range constructed at transit agencies to bypass a review process. And I have much more informed and smarter than me people here to speak about it.
All right. Any questions for Delegate King, or do we want to go ahead and take some testimony and reserve our questions perhaps for anybody who's testifying in favor of the bill?
And I'm sorry, Mr. Chair, there is an amendment
It's been moved and properly seconded. We adopt the committee amendment. Those in favor of that motion will say aye. Those opposed? All right, let's go ahead and start taking testimony from people that are in favor, and if you have, we'll be liberal with asking questions of the person in favor. Oh, do you want to report the amendment, counsel? You want to tell us what it is?
Mr. Chairman, on line 68 of the bill, after property, strike the remainder of line 68, all of line 69 and 70, and through the word specifications on line 71. And insert shall be exempt from review and inspection pursuant to section 108.2 of the Uniform Statewide Building Code pursuant to 13 VAC 5-63-80 of the Virginia Administrative Code.
Okay. Delegate Coyne, I'm going to recognize somebody from the committee here. So I'm sorry, can you introduce yourself first? You're the expert.
One of them. I'm Danny Plugger. I'm the executive director of the Virginia Transit Association.
Okay. You are the executive director of the Virginia Transit Association?
Yeah. And we also have Director DeBrule, the director of the Department of Rail and Public Transportation here as well to help with any process questions.
Okay. So Delegate Coyne, you have a question?
Mr. Chair, so I know that the delegate is not here to speak, and I appreciate the Delegate Munden King. But being in the Richmond region with Delegate McQuinn, I'm very familiar with this bill. This is a great bill. I think those who are all, I see so many people lined up who want to speak in favor of it. We worked really hard in a bipartisan way, Delegate Carr as well, on this issue. So I just want folks to know, without how many of you lined up, you won't hear any negative stuff, I think, on either sides of the aisle on this. So if you're a thumbs up, it might be helpful.
All right. So with that admission, that given where we are now, unless we hear something that we don't like, it's likely to be successful. So the more we hear, the more likely we are to hear something we don't like. Would anybody like to speak in favor of the bill? All right. Is there anybody who would like to speak in opposition to the bill? All right. Is there a motion? It's been moved and properly seconded. We report as amended. The clerk will open the roll.
You're welcome. I told you it'd be worth the calling on me, Mr. Chair.
The clerk will close the roll. Delegate Corner, you did not let me down. The bill reports 7-0. Delegate Munden King.
Thank you. I hope my bill will be as successful as Delegate McQuinn's. The next McQuinn bill is House Bill 578, which increases the fines from $2,500 to $5,000. From $5,000 to $10,000. The maximum that a person or corporation shall be fined with violations of the building code. This bill also adds penalties for blighted multifamily properties. And I'm not sure if we have an amendment. I think the bill is before you in the form that Delegate McQuinn would like. And we have some folks here who can speak more to the subject matter.
All right. And it looks like council is distributing some photographic evidence in support of the bill. So members will have copies of that. And so we'll go ahead and hear from folks in favor of the bill.
Thank you, Mr. Chairman, members of the committee. Mike Sherman with the County of Henrico. Would like to thank Delegate McQuinn and the delegate for presenting the bill. There's been a lot of talk in the halls around here this year about affordable housing, almost all of it dealing with quantity and lowering the barriers to bringing more units online. This bill deals with the quality of our existing stock. It has its origin in a national night out where our board and county manager and agencies and police were out throwing ball with folks and little kids in one of our communities when the maintenance folks came out with lawnmowers to cut the grass, which sounds like it's a good thing. The problem is that not only did they cut the grass, they just mowed over all of the trash. And the county manager and the board stopped the folks and said, hey, wait a minute, what's happening here? And they're like, what are you talking about? We're cutting the grass. We're like, this is not acceptable. And the response was, well, nobody cares. Our manager and our board members said, hey, wait a minute, we care and this is not okay. That exchange led to the citizens in that community opening their homes to us to show us the conditions that they were being forced to live in and describing their fear of the company and its management. The pictures in front of you are but a small example of the conditions that they lived in. There were units that were described to us from the people that were there that you couldn't cook on the stove and flush the toilet at the same time. You had units who were discharging sewage into the crawl space. You had holes in the units that when the residents had complained about it, it looked like they had taken an Elmer's glue stick around the edge of the hole and literally ripped out a piece of notebook paper out of a spiral notebook and stuck it on the wall, in addition to the ones that are in front of you. We've been battling an out-of-state slumlord who is currently in the middle of multiple criminal actions in other states for 6 years with the tools that you have provided us, the existing tools that you provided us in the code. 350 citations that have included over 2,200 violations, 116 criminal court hearings, a blighted declaration, a rental inspection district, a court-ordered injunction, and Mr. Chairman, members of the committee, that's not county-wide, that's one owner with one property. All of those efforts have yielded $65,000 in fines to the owner. That's just north of a little over $10,000 per year. The response from those folks was that that was the cost of doing business. Mr. Chairman, members of the committee, we're here because our citizens are more than a cost of doing business. The bill that is in front of you is a product of those 6 years of work and working with our judges to address some of the difficulties that we've had. In general, the bill does three kind of major things. It brings these sections up to date and harmonizes some of the inconsistencies. It creates a new tool that when we've exhausted all of the other tools, it adds some teeth in the form of increased penalties for repeat violations so that it changes the math for those that seek to use our citizens simply as a cost of doing business. And lastly, it defines the default abatement period should it not be included in the judge's order. I'm happy to answer any questions.
Any questions from members of the subcommittee? All right, is there anybody else in the audience wishing to speak in favor of the bill?
Mr. Chairman, Ron Clements, I'm the building official for Chesterfield County to the south of Henrico, and I spent quite a bit of time talking about these issues. We're having the same issues, and they're happening all over the state. So on behalf of the Virginia Building and Code Officials Associations, we do support the bill.
All right.
Chairman, members of the committee, Laura Dodds with Housing Opportunities Made Equal, and we support the bill.
Okay. Anybody else who's here in favor just doesn't want to speak but wants to be recognized? All right, is there anybody here in opposition to the bill? All right, I want to, before I recognize anybody, I do want to be clear on one thing. We have a sort of a rule of thumb, and you may have heard me talk about it before, where we don't legislate the building code. And just to be clear what that means we don't say, that the Department of Housing and Community Development shall amend the building code so it says this, right? This isn't that, right? This bill doesn't touch the building code, doesn't affect what the standards are, doesn't set anything like that. It just says if you violate the existing code, this is how you're punished for that, essentially. And this is a graduated form of punishment. And I think it sounds like the idea behind the bill is to ensure that the deterrent of those punishments is sufficient to actually make them improve and correct the things rather than just keep paying the fines. So with that, Delegate Coiner.
Thank you, Mr. Chair. I'll start by saying I'm going to support the bill, but a couple of things that I think perhaps maybe we should look at between now and fall. And I kind of talked to some of the folks who help work on this, that there's just a couple areas.
It's only an hour or two, just so you know. Full is this afternoon.
Okay, well, then a very short time period to work on it. A couple of things I think we should consider. Lines 27 and 28, where they struck out involving the same property. The difference between your first offense and the jail time associated with a third offense, if you're getting a first offense on different properties, perhaps it shouldn't be cumulative just because jail time's involved with that third offense, that if it's not the same property, maybe we should make it involving the same property, something to think about. Again, it's all bad, but I'm just saying the difference between a first and a third offense. And then the only other thing that I have a question about for those who have gone through the abatement process with one of these properties, I see in line 62 and 63 where it says the abatement period should not be longer than 6 months, what I'm fine with. But is 7 calendar days, if the court doesn't define one, long enough to really do anything? Or are we automatically setting somebody up to get a second offense within 7 days? I'm just asking the question if any stakeholders here have gone through that process and know the answer, or if we should adjust that 7 days. That's my question.
Is there anybody here who wants to speak to that question? I think the answer is.
They'll figure it out
they'll
between now and fall.
Okay.
That's what I said. I'm going to vote for it, but we can figure those two things out.
Okay. All right. Anyone else have any questions or concerns about the bill? Delegate Munden King.
Thank you, Mr. Chair, and thank you, Delegate Coiner. I would like to, between now and your committee this afternoon, take those suggestions to the, so if we could keep it intact, and then I'll take those suggestions to the patron.
Yep, no, there'll be no amendments at this point. I would say appreciate Delegate Coiner's suggestion about the involving different properties. I don't know that we have consensus on that. I'm kind of okay with somebody, because I don't want them breaking it up into different properties. If you're doing the same thing here and literally right next door and literally right next door, I don't mind viewing those as separate offenses for this purpose. But we can talk about it. But I think
I think the patron would be amenable to that change.
Okay, we'll see.
Do you want to do an enactment, or you want to just move it forward?
Let's just move it forward because we're going to get full.
Mr. Chairman?
Yep.
Make a motion to move the HB 578.
There's been a motion to report. Is there a second?
Second.
All right. It's been moved and properly seconded that the bill report. Were there any amendments? Nope, not yet. Okay. The clerk will open the roll. The clerk will close the roll. Delegate Arnold did the job of making sure this stays on the contested block, and we get back to these things. Appreciate that. Delegate Munden King, you have one more?
Yes, thank you, Mr. Chair. Hopefully my
DBI.
bills will be as lucky. I mean, 2 for McQuinn, and what does that leave me with? I have House Bill 1461, and I do have an amendment in the nature of a substitute. I'm not sure if the council you haven't received it yet.
So can I get a motion on the substitute?
So moved.
It's moved and probably second. We adopt the committee substitute. As many as favor of that motion will say aye.
Aye.
I heard some ayes. Those opposed? We can always wind it back if we don't like it. All right.
Sorry.
So the motion carries. The substitute is now before us, and council is handing us out a paper copy of what it says. All right.
I'm happy to explain.
Go ahead and explain. While it's being handed out, Delegate Munden King, why don't you tell us what's happening?
So, Mr. Chair, what started as a very ambitious bill related to short-term rentals has been changed somewhat, but still achieving what I think is quite a noble goal, which is to allow those who are renters to engage in short-term rental with approval of the owners. So what the substitute does, it is essentially says that localities cannot deny renters the opportunity to participate in short-term rental opportunities solely because they are renters.
All right. I see we have some folks online. Let me, as it's going around. So again, I think what you had is you're trying to do the same thing, but you actually ended up giving lessees and sublessees by accident way more protection than the owners themselves. And so what this substitute does is it says this can't be the sole basis. So you can't just have a rule that blanketly says lessees and sublessees can never be a short-term rental operator. Is that it?
Correct.
Okay. All right. This is 1461. Is there anybody in the audience wishing to speak in favor of the bill?
Mr. Chair and members of the committee, Mary Lawson, representing the Virginia Realtors. We thank the delegate for working with us on this, and we support the bill.
Mr. Chairman, Ron Jordan, on behalf of Airbnb, we appreciate the delegate bringing the bill forward and support it.
Bisma Ahmed with the Apartment and Office Building Association. We also support the bill.
All right. Is there anybody in the audience wishing to speak in opposition to the bill?
Mr. Chairman, Joe Lurch with the Virginia Association of Counties. And what I'll say is the introduced bill we had a lot of issues with. We just saw this language about 30 minutes ago. So I just wanted to register. We still need to evaluate that and just see how it comports with the ordinances that are at the local level. Just wanted to register that. Thank you.
Anyone else wishing to speak in opposition to the bill? Hey, I want to slow down just for a second, Delegate Munnigan, because it's on the sort of, I would call it sort of a blue cover of amendments, right? It hasn't gone through the DLS and drafting and proofing and editing process. But it looks to me like the only real difference here, it's almost going to be a line amendment, is that from offering such property as a short-term rental, and we insert solely on the basis that the operator is got it. It's really only one long sort of run-on sentence, so it's council's taking a look at it now. I see them both taking a look. I think this is probably we've adopted it. Do you want to go by temporarily? Okay. So Delegate Munnigan, we're going to go by temporarily. We may or may not need you back. All right. So if we need you back when we come back to it, well, we'll let you know. But gotcha. Sorry. Online, we've got Margaret Durkin. Margaret, why don't you go ahead and we'll take your online testimony as well. Margaret Durkin.
Thank you and good afternoon, Chair Simon. My name is Margaret Durkin and I'm the Mid-Atlantic Executive Director for TechNet, a tech trade association. We are in support of House Bill 1461 and appreciate your support and the sponsor's commitment to this issue. We will say that in the bill, there is a written attestation by the property owner that allows them to allow their subletter or their lessee to rent the property as a short-term rental, which provides guardrails. So again, thank you to your support and TechNet support to the bill.
All right, thank you. And Ruth Whitaker.
Good afternoon, Mr. Chair. Thank you, and members of the subcommittee. My name is Ruth Whitaker, and I'm the Director of Civic Innovation Policy at Chamber of Progress. Chamber of Progress is a tech industry association promoting technology's progressive future. Our partners include home sharing platforms like Airbnb, but our partners do not have a vote or veto over our position.
Are you for the bill?
I am, yes, in support of HB 1461.
Sorry, I don't mean to be rude. We've got a long docket. We got to keep going, and I apologize
No, of course.
if I cut you off from your prepared testimony. All right. Anybody online wishing to speak in opposition to the bill? We had Mr. Adam Charney of the town of Cape Charles signed up initially. He's not here. All right. All right. There's a motion properly seconded to take this bill by temporarily. Let DLS look at the verbiage, and before the end of our subcommittee meeting, if we need you back, we'll let you know. Okay.
Thank you, Mr. Chair.
All right. Without objection, by temporarily. All right. Yep. All right. Delegate Williams, we are taking your bill by temporarily. At the request of Delegate Price, we are bringing you back so you can get yours over with.
Mr. Chair.
Delegate Price.
Yes, thank you. So DLS, as amazing as they are, came up with some draft language. There is one situation where I wanted to make sure that if I were the person that was needing to purchase one of these systems, that even in the statement, if I received the advertisement, if there's a way to know that if I buy from this vendor, it didn't count. So I need to only buy from the actual vendors that I should be buying from. So we are in agreement in where we're trying to go, but just haven't gotten there yet. And in order for us to continue moving, I would ask that we amend it by adding a reenactment clause so that we can move it forward like we have done with some of the other bills, but allow for DLS and the patron to have a little bit more time.
Is there a second?
Second.
All right, moving probably second. We amend this bill by adding a reenactment clause. As many as fair the motion will say aye.
Aye.
Those opposed? All right, is there a motion on the bill?
Move to report as amended.
Move to report as amended. Is there a second?
Second.
It's been moved and properly seconded. The bill report with amendments. I'm talking faster because Chairman Torian is watching. The clerk will open the roll. The clerk will close the roll. The bill reports as amended, 8-0. Thank you, Delegate.
Thank you for your help.
All right. Delegate Keys-Gamarra. You also have a substitute, don't you?
I do, and I have copies. It was submitted to DLS, but I know I'm in lots of these meetings, and oftentimes.
All right, can I get a motion on the substitute? It's moved and properly second. We adopt the committee substitute. As many as favor of that motion will say aye. Aye. Those opposed? All right, the substitute is now before us. Copies are coming around to the members. Delegate Keys-Gamarra.
Yes, thank you, Mr. Chair, members of the committee. House Bill 1475 is a continuing effort to recognize the needs of constituents in my district who have made contact with me and made it very clear to me that they believe there have been changing temperatures affecting them as tenants within apartments. This bill seeks to allow landlords to recognize those temperatures, that temperatures have been changing and impacting the residents without inappropriately impacting the building code, I believe. This is a simple change, and there is precedent for it. The last change occurred, I believe, in 2019. And I've had an opportunity to speak to stakeholders in both the Home Builders Association as well as apartment associations, and they have settled on the language that I just handed to you. I do believe there's at least one witness online and a couple of folks here who would speak in support of the bill.
So, Delegate Keys-Gamarra, thank you for this. So it looks like, in looking at the substitute, what you're doing is you're asking the Board of Housing and Community Development to at least consider it's a Section 1 bill, so it doesn't have the force of law. It just sort of says to them, we would like you to please look at what we might be able to do to make sure that people get air conditioning in the summer and heating in the winter. Is that basically it?
Basically, yes.
Okay. And so it doesn't quite, walks right up to that line, but does not cross the line of directing anything to happen. And so I think you've been wisely counseled on how to avoid the don't legislate the building code violation. Is there anybody else in the room that wants to, if you're here in favor of the bill, if you could just stand up? Anybody? Bismarck? Okay, go ahead. Realtors, you guys are on board? Okay. Anybody here in opposition? Okay, online, Sheila Casey, if you want to briefly tell us what a good bill this is.
Great. I asked Delegate Keys-Gamarra to submit this bill because the law as currently written causes real suffering. There have been times when it's in the 90s in my apartment in April or May, and I have to find somewhere else to go. I literally cannot use my own apartment due to the heat. People who live in single-family homes might not realize how heat can build up in an apartment buildings because there are so many shared walls. And apartments often have windows on only one side, preventing a cross breeze that could flush the hot air out. The only possible argument against mandating that landlords turn the AC on earlier in the year is that the heat might be needed because many of these buildings can only supply one or the other at a time. But the fact is that a cool day is much easier to deal with than a hot day. Simply closing windows, putting on an extra sweater, sipping some hot tea, or taking a hot bath can make a cold day tolerable. And space heaters are only $20 on Amazon. So the coldest part of the day is at night when most of us are in bed under the covers. But we're up and about during the day. Many of us are working from home. And if it's in the 90s, what are we supposed to do? So the law as currently written says that landlords must supply heat until May 1st, which means where I live, they cannot supply AC at the same time. So they have until May 15th to turn on the AC. And my experience has been, we really need the AC during this time much more than we need the heat. I would like to see the law changed and have the landlords be required to turn on the AC earlier in the year. Delegate Keys-Gamarra has asked for that to be April 1st. Thank you.
Thank you, Ms. Casey. And thank you, Delegate Keys-Gamarra, for bringing this constituent request bill. Delegate Price.
Yes, Mr. Chair, I would like to speak to the bill and have a motion at the appropriate time.
Delegate, why don't you make the motion and speak to it?
Okay, thank you. I move that we report the substitute, and I'd like to speak to that motion.
Delegate, is there a second?
Second.
All right, Delegate Price, speaking to the motion.
Thank you. I'd like to tell the patron that I actually worked to get the 77 down from 80, and that is when I learned that we don't legislate the building code. So I appreciate your diligence with this, and I would also encourage you to follow it through the process because you really do get to learn a lot about what happens through the regulatory process. And yeah, so that's the motion. Thank you.
All right, Delegate Corner, speaking to the motion.
I just want to say happy to follow your example and learn. Thank you.
Delegate Quiner, speaking to the motion.
Speaking of the bill, Mr. Chair.
Delegate Quiner.
I'm not going to vote on this because it will give my parents ammunition to make me turn the heat up in my house. I keep my heat between 65 and 66. I just like it chilly, and they complain when they come visit. If I vote for this, they're going to be like, well, you're okay with it being warmer. I'm just kidding. Thank you for the bill, delegates.
The clerk,
So good.
the clerk will open the roll. My screen doesn't show it. Do you have it? The clerk will close the roll. The bill reports by a vote of 5-2. Thank you, Delegate Keys-Gamarra.
Thank
Delegate
you,
Lopez, I know you're trying to chair another subcommittee at the same time. You've got 3 bills. So why don't we take you?
Thank you, Mr. Chairman. Members of the committee, I really do appreciate the opportunity to go quicker. In fact, let's make it even faster. Can we have one bill go by till 2025?
Which one is that, Delegate?
It's it's not 957, it's not 955. It's the one we talked about earlier.
954. All right, is there a motion to take House Bill 954 by till 2025? Moved and properly seconded. As many as for the motion will say aye.
My God, what kind of chair are you? What?
Those opposed? All right, House Bill 954 is carried over to the 2025 session pursuant to Rule 22.
You're okay with this? Okay.
House Bill 955, Delegate Lopez.
Thank you. Thank you.
A vote, too, remember.
Thank you, Mr. Chair. I really do appreciate it. 955, we do have a substitute, and I'd happy to speak to it after maybe moving to accept the substitute.
All right, is there a motion?
Move to accept the substitute.
All right, is there a second? Second. Moved and properly seconded to adopt the committee substitute. As many as favor of the motion will say aye. Those opposed, no. The substitute is properly before us. Delegate Lopez.
Thank you, Mr. Chairman. I also have one quick amendment on line 162 after required to say upon request of the prospective tenant.
All right, let's give us a second to catch up and make sure the substitute comes up. So, again. All right, and I appreciate everybody working hard. It does have a note that it needs to go through, what do you call it, editing here. So which line is that you have to make the line amendment?
It's 162, sir.
All right.
After required upon request of the prospective tenant. And then one additional amendment on line
Required, so we're talking about communications languages other than in English that will be required to be provided upon request of the tenant?
Request of the prospective tenant.
Request of the prospective tenant.
To provide the summary.
No, I'm sure that makes sense. I understand what you're trying to do.
Comma, upon the, shall be required, comma, upon the request of the prospective tenant, comma, to provide the summary.
The summary page. Okay.
And then on the line 143, one final amendment after applicant, to provide an applicant, comma, upon request, comma, a written rental agreement.
Gotcha. So in 2 places, we're adding language that says upon a written request because we don't want it to apply accidentally to every applicant. They have to ask for it. All right. Is there a motion on the line amendments? All right. So moved and properly second, we adopt the line amendments. As many as favor of the motion will say aye. Aye. Those opposed? Those ambivalent? All right. The amendments are properly before us.
So speaking to the substitute, Mr. Chairman,
Lopez.
In response to stakeholder concerns, we've altered the bill slightly to require DHCD to create a standard cover page forms in the languages that the Commonwealth generally provides to documents. Landlords would then be required to fill out these and include them with their leases upon request. The substitute also adds these that those who manage more than 4 units would also be required to comply with the requirement. And so I can speak to the bill now.
Go ahead. So I understand what the substitute does. So tell us again what the purpose of the bill is.
So leases are a contract. One of the earliest issues lessons we learned in law was in law school is to read and understand every part of a contract before signing. However, when leases are signed, rarely does a tenant have a lawyer present, or in the case of countless new Americans that call Virginia home whose language is not English, they don't have a translator. That's the problem. How can a tenant possibly be expected to understand the content of a lease contract if they don't fully understand the language it's written in? This bill would simply require that a landlord who owns more than 4 rental dwelling units or 10% stake in 40 or more units in any locality in the Commonwealth regularly provides official government communication that in any locality that regularly provides official government communications in languages other than English shall, upon request, provide a summary page with the key terms of the lease and languages used for official government documents in that locality. The amended language would require that DHCD create a form that all landlords would then be able to use. This is simply about making sure tenants know what they're signing up for. Let me repeat that. This is simply about making sure tenants know what they're signing up for. For many Virginians, that can only be achieved by providing them key provisions of the lease in their native language. I hope it's the pleasure of the committee to refer the bill.
Okay. Thank you, Delegate Lopez. Again, so I'm understanding, just again, to very quickly summarize, if somebody doesn't feel comfortable just trying to read through the thick part of the whole contract, they can ask for a landlord to fill out the DHCD summary page with things like fees, rent,
right?
Yeah, how much termination time they get, and so forth. And if they live in a place like Fairfax that provides its ballots in all these different languages, or Arlington or whatever,
right?
That'll be that's where we'll get the list of languages they have to use. All right.
It would be less of a concern in, say, Chesapeake, but it would be more of an issue with like the 6 major languages in Arlington.
All right. Is there any questions from the subcommittee? Anyone in the audience wishing to speak in favor of the bill? City of Alexandria is in the House.
Mr. Chairman, members of the committee, Sarah Taylor, City of Alexandria, we spent some time this interim looking at things that were going to keep people from getting to the point of eviction, and understanding your lease, understanding what you're getting into, and especially for folks for whom English is not their first language, giving them that information in the language that they can best understand it was something that we thought was a reasonable thing. And we appreciate the guardrails that have been put on. We appreciate the patron and hope you'll support it. Thank you.
Okay. Is there anybody here in opposition to the bill?
Thank you, Mr. Chair. Erin Corman with the Realtors. This is a very gentle opposition, and I want to thank the delegate because we met today and we spoke at length about this bill. My members just still have some concerns. Nothing about the translation is a problem. It's the addition of forms. We have several bills this year that are adding forms to the lease and increasing the font size. And these leases are already so long. And if we continue to add forms, add cover sheets, it's just going to make them longer, and it's confusing because a lot of times these forms aren't legally binding, and it only makes things more confusing. So we are not opposed to the translation part. I think that's great, but we just have concerns about the number of bills that are going through this session that are adding additional forms to the lease. And like I said, I'm happy to continue working with the delegate on this. We had a very good meeting earlier today, but my members are still a little concerned about that.
So does it make you feel any better that this form is only required to be provided upon request? So in other words, we're not adding to the lease unless somebody says, wow, this lease is too confusing. Is there a summary that I can get? Does that make you at least feel a little bit better about it?
Yes, it does.
Okay. Thank you. Delegate Coiner? All right.
Mr. Chairman, members of the subcommittee, Zach Lemaster of Gentry Lock here on behalf of our client, the Northern Virginia Apartment Association. We would just associate our comments with the realtors as well.
All right, so gentle opposition so far is what I'm hearing. It's getting gentler maybe, I don't know.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association, Virginia Apartment Management Association. Another gentle opposition. We have no opposition to the translation part of it. We worked with the delegate on a separate piece of legislation on the fee summary, so want to get there, but.
Thank you. All right, Delegate, so the lights have gone out. So is there any further questions or comments from members of the subcommittee? If not, do operate by motion.
So,
thank you. Moved and seconded to the bill report. The clerk will, with substitute. Clerk will open the roll. Delegate Lopez, it looks like your bill gently reports.
Gently reports. Goodness me.
5-3. Delegate Lopez, you have one more?
One more bill, sir. Mr. Chairman, HB 957. I just called you sir. HB 957 regarding tenants' assertion for condemned rental units.
Right.
There's a substitute before the bill?
We had adopted a substitute, I think, at our last subcommittee meeting, and then we took it by.
And then we have a new substitute.
So there's a new substitute.
Right.
All right, so let's do this. Can I get a motion to reconsider the motion by which we adopted the subcommittee substitute at our last meeting?
Second.
All right, it's been moved to properly second. We reconsider the vote by which we adopted the old committee substitute. As many in favor of that motion will say aye. Those opposed? Okay. So now we got an unamended bill, and now there's a new committee substitute. Can I get a motion to adopt the new committee substitute? Second. It's been moved and properly seconded that we adopt the new February, what day is it? 8th, committee substitute. As many as favor that motion will say aye. Aye. Those opposed? All right, so the new substitute is now before us and it is online? Yes. Okay. Delegate Lopez.
So this new substitute ensures the paying of actual damages, the return of certain rent, and security deposit to dependents in the case where they are forced out due to condemnation of their home, with exceptions for the condemnation of a dwelling unit was caused by the deliberate or negligent or omission of the tenant, an authorized occupant, or a guest or invitee of the tenant. The condemnation of the dwelling unit was caused by an act of God, or 3, the lease was permanently terminated pursuant to 55.1-1240. I can speak to the bill, sir.
So we heard this before, so tell us what's different, Delegate Lopez, from what do you guys change in the interim?
So we've basically kept in the damages, we kept in the attorney's fees, but we've taken out the statutory damages, which gave some stakeholders agita about moving forward, but we still are able to address and make things better for individuals who've gone through this process of having their residences condemned because of some lack of action or response to requests for action by the tenant.
All right. Is there anybody here wishing to speak in favor of the bill as amended? Virginia Public Law Center folks were here earlier.
They're good.
They're good? Everybody's good? All right. Is anybody opposed to it?
Even that way?
All right. I think so. Nobody's opposed to it. I think we have some neutral people. So the committee operates by motion.
Second.
Move to report with new substitute. The clerk will open the roll. The clerk will close the roll. Your bill reports by a vote of 6-2.
Thank you very much, everyone.
Thank you.
Appreciate it.
Chairman Lopez. All right. We lost Delegate Garrett. Delegate McClure. Oh, you know what? Delegate McClure.
I have 3.
Yeah, you showed off. No, I'm going to take Delegate Faganson first.
Okay.
Because he only has one. No, Delegate Faganson, you only have one. Come on, let's get you, because I don't want you to sit. I want to keep things moving. You have other places and other committees to be too. Delegate McClure, I'll come right back to you, I promise. Delegate Faganson is going to be quick, I think. Delegate Fagans.
Good afternoon, Chairman. I have a substitute.
Can I get a motion on the substitute? So moved. So moved and probably second. We adopt the substitute. If anybody's favor that motion will say aye. Aye. Those opposed? All right. The substitute is properly before us and is online. Delegate Fagans, talk to us about your substitute.
Good afternoon, Mr. Chairman and members of the members of the committee. I'm here to look at House Bill 327. I'd first like to thank the chairman and also as well individuals in both sides of the party who have helped us get to this bill where it's currently at. The bill currently has 2 parts in terms of the substitute. First, it requires the Department of Behavioral Health and Development Services to build off the work already underway in the response to the ongoing Department of Justice settlement and collaborate with relevant stakeholders such as government entities, knowledge leaders outside the government, and self-advocates to design a plan to enable all people with disabilities across the Commonwealth, not just those that are included within the settlement agreement, to access inclusive housing. That has always been the crux of this bill, is to try to improve housing for those that are in the disabled community. And second, the bill incorporates a definition of what inclusive housing is. The language aligns with the Americans with Disability Act and can serve as a reference point to promote the full inclusion of people with disabilities now and into the future.
So you guys are looking at the wrong, this is in the substitute?
What's the date of the substitute?
What's that?
What's the date of the substitute?
So it's a 2/8/24 substitute. If you're, I'm on, so I'm on LIS, and if you look at House Committee amendments and substitutes offered, there's 2 listed. One's 125 and one's 2/8.
All right, give me 1 second.
Okay? And what I think, Delegate Fagans, we did was the bill that came, the substitute that came over from the other committee talked about things like work and groups.
Correct.
And studies and things like that. And this much improved substitute talks about working with stakeholders to develop a plan, which is completely different.
It is a plan, that's correct.
It's a plan, it's not a study. They're going to work with stakeholders, they're not going to do a group. So
with such a late edition, I apologize. I should have printed it off to have it for the committee.
So Hold on one second. I'll make sure everybody gets a chance to look at the substitute that I just described. Make sure it says what I think they said and what you said it said. In the meantime, is there anybody here wishing to speak in favor of the bill? Please step forward. Let me ask you this question. Is there anybody here in opposition to the bill? Okay, those of you in favor, note that there's nobody in opposition, but if you want to come forward and just tell us this is a good bill? All right.
I would not take that.
All right, so we have 3 in favor, none against. It's been moved and properly seconded to report with substitute. As many as, well, the clerk will open the roll. The clerk will close the roll. Bill reports 6-2. Thank you, Delegate Fagans.
Thank you, Chairman.
All right. Delegate McClure, you and your 3 bills, come on back. All right, first is a preliminary matter. Let's take House Bill 567 from Delegate Askew. I received a note from him that says he wants to roll this into he wants to incorporate into your House Bill, which number is that?
405, Mr. Chairman.
405.
Second.
All right, it's moved and probably seconded that House Bill 703, I'm sorry, House Bill, what did I just say? 567 goes into 405. As many as favor that motion will say aye.
Aye.
Those opposed? All right, that motion is agreed to. Delegate McClure, quickly tell us about House Bill 405.
Yes, Mr. Chairman, I also have an amendment in the nature of a substitute.
Of course you do. Delegate McClure. Is there a motion on the substitute?
Second.
It's been moved and properly seconded. We adopt the substitute. As many as favor the motion will say aye. Those opposed? The substitute is properly before us. Delegate McClure.
Thank you, Mr. Chair. As introduced, HB 405 sought to incorporate electric vehicle charging infrastructure into new industrial, commercial, and multifamily developments. This prompted a broader discussion about how EV infrastructure will affect local land use and land development, particularly for new single-family and multifamily developments.
McClure.
The substitute, yes.
What does your bill do? Real quick.
Yes, Mr.
Just get to the chase.
It will direct the Commission on Electric Utility Regulation to evaluate and design the deployment of electrical distribution infrastructure necessary to support the installation of electric vehicle charging facilities in new developments consisting of single-family and multifamily residential units, Mr. Chair.
All right. Is there any questions from members of? You got it? Section 1 bill has the Commission on the Electric Utility Regulation to evaluate. It doesn't study anything. It evaluates and designs and deploys things.
Move the report. Second.
It's been moved and probably seconded the bill report. Are there any questions from members of the subcommittee? Delegate Coiner.
Thank you, Mr. Chair. So Housing Commission has worked on this issue. So, there's a lot of great information that's been sitting there. We worked on a bill that was sent to Housing Commission. We couldn't get consensus around the issue, but we did a lot of research and work in it. So just from a policy perspective, I'm not so sure that this particular Commission on Electric Utility Regulation is the issue. It's really more on the housing side of it. So just so that the delegate is aware, this has been struggled over quite a bit.
Yeah, and Delegate Coiner, that's part of the reason we're not sending it back to the Housing Commission. We're trying a different group. Maybe they'll have a different result. So it's been moved and properly seconded that the bill report with substitute. The clerk will open the roll. The clerk will close the roll. The bill reports 5-3. Delegate McClure, you have another bill?
Yes, Mr. Chairman, I have HB 368 or HB 1253.
Which one's shorter?
1253, Mr. Chairman.
House Bill 1253 next.
All right. So, Mr. Chairman, I brought this legislation forward on behalf of my constituents to address the lack of accessible housing for individuals with disabilities. So, as we continue our efforts to increase the overall supply of housing, we must not forget this underserved population. However, through conversations with disability advocates in my community, we've come to a conclusion that there may be another way to achieve this goal more effectively prior to passing this bill. So, I've spoken with several stakeholders, including the Home Builders Association of Virginia, and we have committed to work to advance the changes to the building code that will open up more housing opportunities for Virginians with disabilities. And for that reason, Mr. Chairman, I ask that HB 1253 be continued to the 2025 session.
It's been moved and properly seconded that House Bill 1253 be continued to the 2025 session pursuant to Rule 22. As many as favor of that motion will say aye. Aye. Those opposed, that bill is carried over to the 2025 session. Delegate McClure.
Thank you, Mr. Chair. Last bill. And Mr. Chairman, I do have a line amendment.
All right. This is House Bill
This is House Bill 368, Mr. Chair.
68. And the line amendment is that on line 6 of the title, after the word exit, strike report. And on line 15, introduced after submit, strike the remainder of line 15 through report of. Right? So what we're doing is we're taking out references to any report from this bill. Is there a motion on the line amendments?
So moved.
Moved and probably second we adopt the line amendments. As many as favor of that motion will say aye.
Aye.
Those opposed? All right. Delegate McClure, 368 as amended is before us.
Thank you, Mr. Chairman. HB 368 will direct the Board of Housing and Community Development to provide recommendations for allowing a single-stair exit to serve multifamily residential structures up to 6 stories in height. Currently, Virginia Code prohibits the construction of residential buildings taller than 3 stories to be built with a single-stair means. According to a recent study, the majority of Virginians don't become a homeowner until age 37, so we absolutely have to be innovative in the solutions that we bring, such as buildings with a single staircase. They're increasingly necessary to ensure that every Virginian can afford a safe place to live. So in other states like New York and Washington, buildings with a single staircase up to 6 stories in height are already allowed, enabling larger family-sized apartments and condos to be built. So the benefits of single-stair construction include more available housing, more affordable housing, and more housing choices for residents, especially for those in my district. So
Okay, Delegate Price, you had a question?
Yes.
I have a comment and a motion.
Delegate Price.
Yeah, so, Mr. Chair, I just would like to remind us that we received this bill from Rules, and I have a motion at the appropriate time.
The delegate may state it.
Yes, I move that we report as amended.
It's been moved and properly second. We report as amended. As many as favor of that motion, the clerk will open the roll. Mr. Cancel, I see you online. You're here to vote to support the bill. We appreciate your support for this bill, which is going to pass.
Okay, great.
The clerk will close the roll. The bill reports by a vote of 8-0. Delegate McClure, thank you for your hard work on this very important issue and bringing everybody together. And let's hope that report comes back soon. Thank you for your very quick 3 bills. Delegate Garrett.
Thank you, Mr. Chairman, members of the
Before we
committee.
get to Delegate Garrett, because it's just a tease, I'm going to take up a couple other bills, but trust me, it won't take long. Can I get a motion to strike House Bill 703?
So moved. Second.
It's been moved and probably seconded that House Bill 703 be stricken from the docket. No, you can stay right there. The clerk will open the roll. The clerk will close the roll. The bill is stricken from the record by a vote of 8-0. Is there anything else that needs to be stricken, or is that it?
No, you have one King's bill to come back.
Gotcha. All right, Delegate Garrett, House Bill 1448.
Thank you, Mr. Chairman. I wish I could speak as quickly as you can. House Bill 1448 is maybe the simplest piece of legislation I've ever carried. Essentially, it says that it's unlawful to discriminate against people where you convey favor or detriment based on race, religion, or race, sex, or ethnicity, and it amends the Virginia Human Rights Act.
All right, are there any questions from members of the subcommittee? Anybody in the audience wishing to speak in favor of the bill? Anybody in opposition? All right, Delegate Garrett, my concern with this is that typically we've been working with the Human Rights Act for creating protected classes, and we just talk about specific acts that are unlawful and so forth. This is sort of a broad, any program that does anything that provides or denies anything based solely on individuals' race, sex, or ethnicity. I think it's a little bit hard to wrap our arms around. I think the enforcement would be difficult, and so I'm not going to be in favor of the bill.
Mr. Chairman, I understand where you're coming from. All this says is that you can't discriminate against people based on race, religion, or ethnicity, and if you support discrimination based on those things, then certainly oppose the bill.
Okay, understand. You got the last word. Is there a motion?
Move to gently lay it on the table.
Is there a second? All right, so moved in second that we gently lay this bill on the table. So clerk will open the roll. The clerk will close the roll. The bill is gently laid on the table. Thank you, Delegate Garrett.
Thank you, Mr. Chairman.
Does that conclude our docket? Oh, we have Delegate Munding King. All right, did we make any progress on Delegate Munding King's substitute counsel? Did we get a chance to look at those words, and does that look like it's okay? Okay. So for those of you who didn't hear that, council said that they have had a chance to proofread the changes. They're able to post it online now, and that it looks like it's in good order. So I heard a motion to report that from Delegate Coiner, seconded by Delegate Thomas. All right, so it's been moved and properly seconded that the bill report as amended. The clerk will open the roll. With amendments, not substitute.
It's amended.
All right, the clerk will destroy the roll so we can describe the vote properly. The clerk will open the roll. Here we go. And the members will cast their votes. The clerk will close the roll. The bill reports on a vote of 7-1 with a cautionary eye being kept on it by Delegate Price. I want to thank real quickly, because I know we've got other subcommittees to go, but this is our last meeting. We went through a huge number of bills before crossover. This is our last meeting before crossover. It's all downhill from here, but thank you, Council, Ms. Schultz and Ms. Benz in particular, and thank you to our clerk for all your hard work in managing all those last-minute substitutes and amendments. And with that, the committee shall rise.